We are recording.
Thank you. Good morning. The appellate court for the state of Connecticut is out of recess, back in session Tuesday, April 13th, 10:30 a.m. Appeal, Lampert v. Lampert. I would ask that everyone participating in the hearing identify themselves, starting with the judges, then counsel for the appellant, and then finally counsel for the appellee. I am Judge Alborg.
Good morning, I'm Judge Mull.
Good morning, I'm Justice Norcott.
On behalf of the appellant, I'm Kenneth A. Votri.
Good morning, Your Honors. On behalf of the appellee, Livia Barndollar, Pullman and Cumley, and in the room with me and not on screen is my co-counsel, Joanna Katz.
Okay, thank you. Counsel, part of this argument, you received procedural instructions. Do you have any questions?
No,
Your Honor. Thank you.
Okay. I should mention that the argument is being live streamed, and to the extent that the case involves any protected identifying information, please be careful that it is not disclosed. If by any chance, since we're conducting this hearing over Teams, for some reason you have difficulty staying in the hearing, no problem. We will cease discussions and we will wait for you to log out and log back in. That might also happen to one of us judges, so just letting you know what we do in that situation. I think that's it. Please try to remember to mute if you're not speaking. Okay, so counsel for the appellant, Mr. Votri, Attorney Votri, you can reserve some time for rebuttal. Would you like to do that?
Yes, Your Honor. 5 minutes, please.
Okay. You can proceed.
Thank you, Your Honor. So my name is Ken Votri. I represent the appellant defendant in this case, Sherry Lampert.
Yeah. Mr. Votri, before you begin, can you clarify something for me? Sure. Although there's much mention of contempt in this case and in the record, would you agree that the trial court never found your client in contempt? I'm really referring to page 4 of the memorandum of decision, where it seems that she doesn't find your client in contempt, but uses some extraordinary equitable powers to fashion a different remedy. Am I incorrect?
I don't think you're incorrect. It seems like she made the findings of contempt, but didn't enter an order of contempt and used another remedy to try to give what appears to be the same relief.
So you would argue that there's still a finding of contempt?
I think we have, she did not make a finding that the defendant was in contempt, but then awarded the relief that I would normally expect to see in a contempt motion, which is the payment of the money plus the attorney's fees. So she used an alternative mechanism to get there, although she did seem to indicate that the conduct before the judgment entered under the automatic rules was willful. So are you challenging her remedial authority to do what she did? Yes, Your Honor. Thank you. And I think that's sort of a good place to begin on this case. I mean, the facts are not that difficult in this case. Obviously, this was a marriage that went to judgment way back in 2013, and the stipulation dealt with this Richter painting. The stipulation indicated that the Richter, if it had not been disposed of, would go to the husband. And
Attorney Votri, I have a question about the 2014 stipulated judgment. Yeah. Were the parties canvassed prior to the court accepting their stipulation?
It is my understanding that both parties were canvassed.
Okay, and
I was not there, but I
understand that, but you have better access to the trial record than we do at this point. Were the parties did the parties also submit sworn financial affidavits?
Yes, they did.
And your client's sworn financial affidavit, did it show this asset?
To the best of my recollection, it did not.
So did she perjure herself on her sworn financial affidavit?
She did not have no, she didn't. She did not have the painting at that time.
Did the painting exist at that time?
Not within her possession and control. It had been sold.
And that's because she sold it. Did she receive the proceeds for selling that painting?
Yes, she did.
At that time?
At the time, approximately a year before before, it was approximately a year before the judgment.
Did she record the proceeds of the painting on her sworn financial affidavit?
It does not appear that she did.
Did she perjure herself because she didn't record the proceeds of the painting on the sworn financial affidavit?
I don't believe so, because I think she spent the money, but I don't know that she had it in her possession at the time.
Thank you.
Yeah, I think, to address that at the beginning, there's no question that she did the wrong thing in terms of the automatic orders. I can't.
No, I'm sort of focusing on the perjury aspect.
Yeah, I mean, it appears it was sold. She spent during the course of the pre-judgment period of time a relatively large amount of money, and that the $200,000 was not, in a way, all that significant in the scope of the money that was involved in the divorce at that time. It is now to the parties, but not necessarily then. And the issue is, and I think with Justice Narcott's question, it's also, I mean, the first question to ask is the right question to ask, which is, what did the trial court order? The trial court, in my view of the decision, focused on the behavior of the defendant prior to the entry of the judgment. She sold the Richter painting, and she concealed that fact that she had sold it. And there was also money coming and going during the course of the pre-judgment period of time. The problem is that when the case went to judgment, the Richter painting was dealt with. And the issue is if she had it in her possession and it had not been disposed of, then it would be turned over to the husband. Now, the testimony seems to have been throughout this case that the husband believed that the painting was either lost or destroyed and may not have known that it had been sold. But at the same time, nobody took the position they knew where the painting was. And that's why—
Was there any evidence whatsoever that the husband had been told by your client that the painting had been put in the garbage?
I believe that statement had been made, yes.
Was there any contrary evidence to that statement?
In terms of the hearing on this motion or on the hearing on the underlying divorce? So that
How about both?
In terms of it being sold, there was no testimony.
No, not that. No. I'm sorry. I probably wasn't clear.
Okay.
Was there any evidence at, I assume there wasn't any evidence at this time of the stipulation because we just determined your client didn't disclose this.
Yeah, no,
So
there
was
was.
there any evidence at the time of the hearing on this motion that the painting had been put in the garbage?
No, because at the time of this hearing, the defendant admitted that the painting had been sold. That came out at the underlying hearing in this case.
So I read somewhere about the painting being put in the garbage. Those words did not come out during the hearing on this motion.
No, I mean, other than to the extent they would have come out, to the extent that that's what was said at the trial below, at the divorce below. But at the time of this hearing, the evidence came out that it was sold. And I seem to be recalling that Mr. Lampert stated that he was told by your client that this painting had been put in was water damaged and put in the garbage. But you're telling me that didn't come out at the time of this hearing. No. Let me go back through it. In terms of my client did not testify.
Okay, let me ask my question the third time. Was there any evidence at this hearing that this painting was water damaged and put in the garbage by your client?
The testimony was from Mr. Lampert that he believed that's what she told him at the time of the divorce.
And did she provide any contrary testimony to that?
She testified at this hearing on this matter that the painting had been sold and that she had liquidated it. And what came out is that she'd gotten small payments for it and put over a period of time.
So when she didn't clarify whether or not it had been water damaged and put in the garbage, and in fact that it had been sold. So she was also under oath at this hearing when she testified? Was she under oath at this hearing when she testified?
Yes, Your Honor, and she told the jury that it had been sold. So let me just go through that so I understand your questions. And at the time of the original divorce, what Mr. Lampert had said, and I don't think that my client disagreed with, she told him that it had been destroyed or had gotten water damages and was thrown in the trash. At the time of the hearing on the contempt, she testified that, in fact, no, that's not true. She had sold it. At the time of the divorce, that painting, that statement was between she and her husband, and I don't believe that was under oath at that time. Here, in this hearing, she did testify under oath, and I think she acknowledged, I didn't disagree, that's what she had told him prior. So there's no question, and Your Honors, I can't say anything other than she was not straightforward and honest at the time of her divorce. And the issue, however, in this case was that at the time that the judgment did in fact enter, that painting was dealt with based on a question as to whether or not it existed or not. And at that point, the husband had testified in this hearing that he didn't believe it existed, that it had been thrown in the trash. She did not reveal at the time of the divorce that it had been sold. The issue is now the judgment enters in 2014, and I misspoke before saying 2013. So the judgment enters and a provision is negotiated to deal with the Richter painting. And if you read that provision, clearly it indicates that there is not necessarily accurate information as to the existence of that painting. And so it did indicate whether or not, if the painting was in her possession, she would turn it over. If it had been disposed of, it would not. Correctly, and when the trial court looks at the separation agreement, indicates that disposed of is not defined in that judgment. However, in the case of contempts that exist prior to the date of the judgment entering, those contempts are merged into the final judgment. So the dispute with the judge here is what the remedy would be for that type of action. Now, the judge does indicate that she can't find a contempt because it was prior to the date of the judgment, but then is critical of her behavior pendente lite, and essentially finds all the factors she would have found if, in fact, she was finding the person in contempt for purposes of a pendente lite motion for contempt before the judgment. But once the judgment entered, the issue of the painting was resolved. And one of the issues is, does the contempt continue? And it doesn't. And the Papa case that the trial court relies on deals not with a property division, but about the payment of support. And that's a much different issue. It talks about a liquidated debt at the time that during the course of the divorce. That's not what we have here. Oddly, in the separation agreement, the Richter painting is to go to the husband, but if it's been disposed of, it doesn't go to the husband. And the clause doesn't say what happens if that's the case. Does he get a car? Does he get money? It simply says if it's there, it goes to her. So she's complied with the separation agreement. And the separation agreement says exactly what's there. Now, Your Honors, I could see an argument that could be raised by the husband saying then the judgment should be opened on the basis of fraud because there was a material misstatement about assets at the time of the divorce. But of course, that's not what the plaintiff in this case is asking for. So, Your Honors, I know it's hard to make an argument that your client did something bad, but we're now post-judgment, and because it was the issue of the possession of the Richter was in question at the time of the divorce, that the divorce judgment is the final order relating to that Richter. And so a contempt motion as to a violation of the separation agreement may be even, would certainly be arguable. I don't know that it should prevail because of the language of that provision, but that's not what the plaintiff brought in this case. What the plaintiff brought was a contempt motion relating back to the automatic orders prior to the judgment. And while it may seem inequitable, it is the way the law in Connecticut is in order to reach a point that divorce judgments are final. What's more relevant here too is that provision dealing with the Richter painting is a property division, part of the property division.
Attorney Voter, before you finish with your primary argument,
Sure.
Could you just go back to Justice Norcott's question in your answer?
Yes.
And not focus so much on the contempt motion, rather the judge's authority or lack of authority to make the remedial orders she made?
Sure. Judges have, of course, authority to make remedial orders, but for two reasons, the judge didn't have that authority here. First, the orders that were seen as remedial orders were made as to the property division. It affected the paragraph dealing with the Richter. The paragraph with the Richter did not provide that there was an amount to be paid if the painting didn't exist. There wasn't an alternative property award for the paintings. That's what for the painting. That's what the parties agreed to. So
you're relying on a narrow reading of the phrase in the stipulation when that phrase originated with a lie on the part of your client. Is that a correct statement?
No, Your Honor.
What part of that is incorrect?
No, because I don't believe that paragraph arose because of a lie on the part of my client.
What did your client tell her
First
spouse
of all,
had been done to the painting?
Sure,
We circled all the way back to my original question.
I know, Your Honor. Of course, she said that it had been trashed. It had been put in the trash.
Right. And that was you're saying that wasn't a lie?
No. I'm saying whether or not, because Your Honor, to address your questions in a straightforward way, you connected it in terms of causally with the entry, with that paragraph being put into the agreement.
Right.
I think at the time that was put into the agreement, the parties did not have a firm understanding of where the painting was and whether or not she had possession of it, whether or not she was.
Did your client not have a firm understanding that she communicated to her spouse as to what happened to the painting?
She knows exactly what she said.
Right.
But here's the thing. Once the agreement, let's assume it was a lie. Is the remedy, modifying the property division, which is what the judge did, or is it fraud at the time you entered into the divorce? Because in the normal situation, these are unique facts. In a normal situation, it's going to be husband or wife didn't tell me they had X, Y, or Z. That is fraud. I want the judgment opened. I don't believe the remedial orders allows the return to the mosaic of the resolution of the case, when in fact, whether or not she had sold it or not, it understood that the painting may not be going to the husband for one reason or the other. And so I'm sorry, if you want to ask a question, I don't.
Not at all. I just want to let you know that you're over your primary time, probably because I've asked too many questions.
All right.
Judge Small has a question.
Before I leave. Attorney Barndollar, I want to ask you, Attorney Votri. So with respect to the provision in paragraph 15 that says essentially that the plaintiff would be entitled to the Richter painting, quote, if the defendant has not disposed of it.
Yes.
With respect to that clause, if the defendant has not disposed of it, is it your position that that clause is plain and unambiguous or is ambiguous?
I think it's plain and unambiguous. Either it's disposed of or not disposed of, and it doesn't specify sale or any other reason, and I think disposed is a clear word. If she had possession of it, it clearly states that she has to turn it over to the husband.
And do you agree that the trial court essentially found that the parties at the time that the stipulation was entered intended for that clause to mean if the defendant has not thrown it out?
I think that's the way the testimony came out, but I don't believe you get to the step of interpreting the language in that paragraph because it is not ambiguous. It's either disposed of or it's not disposed of. And to relate back to another question, I think I'm reading disposed of as a relatively broad term, which was that she was no longer in possession of the painting.
And with one more question then.
Sure.
So with respect to parole evidence, I didn't understand your position because in your principal brief,
Yeah.
you state that the trial court considered parole evidence. I'm looking at page 6 of your principal brief. And then in your reply brief, you say that parole evidence was not admitted. So what is your position on parole evidence?
It appears that the judge did not make an analysis that indicated I'm going to allow parole evidence on this issue. It does seem that the court considered some testimony as to what the belief of the parties was as to the terms of that provision. But I don't know that there was actually a determination that it was ambiguous. So I think the statement in the decision, if I recall it correctly, was that there was no definition of the term in the separation agreement, which I agree, there was not a definition of disposed of.
All right, thank you.
And if that's the only type.
Yeah, so we'll go to Attorney Barndollar now. Thank you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court. It is a fundamental core of the defendant's argument, the appellant's argument, that the court improperly held her in contempt, or if it didn't hold her in contempt per se, that it punished her as if it was holding her in contempt, and that the court could only have awarded attorney's fees if they had found her in contempt under 46B87. The first problem, of course, is that it is not the case that the trial court held Ms. Lampert in contempt, and it didn't punish her, it fashioned remedial orders. So I need to correct some facts that were said, were answered incorrectly in response to the questions that were raised by Your Honors to Mr. Votri. Ms. Lampert did testify, the appellant did testify at the time of before the dissolution judgment that she had thrown away the Richter painting. She testified under oath. She testified in February of 2014 at her deposition, just a little more than a month before the judgment entered, and almost a year after she had sold the painting and refused to take the funds from the painting into her hands. It was impossible for Mrs. Lampert to have spent the money that she ultimately received, the $200,000 she ultimately received, during the pendency of the action because she refused to take it into her hands. That was clearly presented at the October 2018 hearing on this motion. It was presented by way of the Philadelphia Art Gallery owner, whose entire deposition transcript and exhibits were admitted, and it was acknowledged by Mrs. Lampert under cross-examination. She not only refused the $200,000 check that she was sent, but she then had $50,000 of it sent to a gentleman who no one really knew at the time of the October 18 hearing, but at that time she said she still had not been given the money by that gentleman. So as of October 18, she had still not taken the first $50,000 into her hands. The second $50,000 that she received in five $10,000 checks was received more than a year after the dissolution judgment. And the last $100,000 she actually sued the gallery for in 2016, which alerted Mr. Lampert for the first time that, in fact, the painting had not been put in the garbage, as she testified both at her deposition, but also in October of 18 at this hearing, and in fact had been sold by her. To the comment that she didn't testify at the hearing in October of 18 about what she had said about the painting being in the garbage, I refer, Your Honors, to pages 3 and 5 of our brief. She did indicate at that time, on 10/16/2018, that she had thrown it into the garbage, and she admitted that she had given sworn deposition testimony that it was in the garbage heap, quote unquote, due to water damage, and she had thrown it away. And in she also responded to her attorney that she had taken it out of the garbage, that selling it for $10 was better than not getting anything. During the time period of the summer of 2013, when Mrs. Lampert didn't have the money, the $200,000 in any bank account, because she had sent it back to either the art gallery or to this Mr. Roa, who still owes her $50,000. She did not put the loan receivable from Mr. Roa, nor the amounts that she was still entitled to, the $150,000, on her financial affidavit. She filed subsequent financial affidavits at the time of her deposition in February of 2014, and she filed final dissolution judgments. On none of them did she put down any of the $200,000. So she didn't spend it because she made a very careful effort to make sure that it was not in her hands. And she testified that she did that willfully and didn't put it on her financial affidavits because she didn't want Mr. Lampert to know about it. So when the words disposed of were used in the stipulated judgment, they were used to mean thrown away because Mrs. Lampert made sure that everybody thought it was thrown away. And when Mr. Lampert found out that it had actually been sold, he sought relief from the court. Now, obviously, at that point, the precise order could not be enforced, and so the court had authority to fashion a remedy both appropriate to vindicate the judgment and to make him whole, because no longer could he actually have the painting. But it is not a situation that is equivalent to what Attorney Votri argues, the appellant argues, that there was either the painting or nothing. What everyone expected, the way that the judgment needs to be interpreted, given what was understood at the time of the dissolution, was that there would either be a painting or there would be nothing. But in fact, there was no painting, but there was $200,000. So I submit that it's entirely within the well-honored, rich line of cases that in circumstances like this, remedial orders are warranted. Essentially, what Mrs. Lampert is arguing is that because she lied and she got away with it long enough for it to, quote, merge into the dissolution judgment, that the court can't provide the remedy that the cases like Lawrence versus Cord, Clement versus Clement, and many other cases that started back with Lawrence versus Cord and have continued on through as recently as 2019 allow. So the court had the authority to exercise its continuing jurisdiction to effectuate the judgment, and it did. The trial court had the broad discretion to make Mr. Lampert whole, and it did. The court also awarded attorney's fees. Now, my first argument with respect to the attorney's fees is that the argument that it was inappropriate for the court to order a fee award under Maris versus McGrath was not adequately briefed. There's no analysis in the appellant's brief of the relationship between the facts of this case and the law cited. Arguably, their claim is abandoned, but the attorney's fees were not ordered on the basis of the bad acts that Mrs. Lampert, they were not ordered based upon Mrs. Lampert's contemptuous actions. They were ordered on her bad faith litigation. So to make that more clear, it is not only because of her failure to abide by the automatic orders that the court has the authority to make the attorney's fees award. The court had the authority to make the attorney's fees award because of her bad faith in the conduct of the litigation and the fact that her claim was not colorable. Her substantive bad faith, her willful violations of the court orders, and the conduct of her instigating and maintaining the litigation, or in this case, maintaining her defense to it, were exemplified in the court's decision. The fact that it was not a colorable claim because she personally had firsthand knowledge of the underlying matter is also clearly laid out by the trial court's findings. Mrs. Lampert knew the facts. She had concealed the sale. She lied about the sale. She hid the loan receivable, which was still outstanding at the time of the October hearing. She returned the check for $200,000 during the pendency of the case. She took $10,000 checks a year after the judgment. She tried to get dollars wired to a chateau in Europe. She finally sued the gallery and cited that the sale was in 2015. And then she didn't put the loan or the receivable on any of her financial affidavits when it was appropriate. So the court did not award the fees based upon Mrs. Lampert's violation of the automatic orders. As the court clearly stated on page 4 of the memorandum of decision, the court found that all of the bases for the exception to the American rule laid out in Maris versus McGrath existed. As for the parallel evidence argument, the issue of what disposed of meant was raised by Ms. Lampert's attorneys, not by Mr. Lampert, not by the appellee, at the time that this motion was brought. At the time that this motion was brought, Ms. Lampert's attorney said there's more than one meaning of disposed of. One of them was thrown away. Ms. Lampert testified at the October 18 hearing that she knew that it was meant thrown away, that she always thought it was meant to be that it meant thrown away. And that was in response to her own attorney's questions. So I agree with Attorney Votri. It's unclear whether there was an ambiguity found or not. But I would submit that the reason that there was not clarity as to whether there was an ambiguity and parallel evidence was admitted was because the argument that there was an ambiguity was an academic argument. It was never an argument that was supported by the testimony. As far as modification of property as a reason why this order was inappropriate, there are a number of cases that indicate that when the court fashions orders to protect the integrity of the original judgment or to make the complaining party whole, that there can be orders that are different. And in O'Halpin, the court ordered that if there is a reasonable interpretation that a motion can be construed as seeking an effectuation of the judgment rather than a modification of the terms of the property settlement, the court must favor that interpretation. An example, and only one example, there are a number in our brief, is that in Clement versus Clement, Mr. Clement was not found in contempt, and he was not found in contempt because he had actually appealed the order of the court, the judgment of the court, and there was a stay of execution. But during that time period, he failed to pay mortgage payments on the house, and the house was supposed to have gone to Ms. Clement, and the house went into strict foreclosure. And what the court did was they provided that Mr. Clement pay Ms. Clement the $29,500 that compensated her for the loss of the equity on the house because it was foreclosed. Mr. Clement made the same argument that Ms. Lampert is making here, that the non-compliance with the court order was extinguished because there had been a merger in the final judgment. The attempt to try to force Mr. Lampert to take on the burden of opening the judgment is specious. The whole reason for the court having the authority to fashion remedies to dignify the integrity of the judgment is so that people who have ways to have the court make them whole without challenging the finality of the judgment can seek for that to occur. For Mrs. Lampert to say that Mr. Lampert, for the appellant to say that the appellee has to go to the court and move to open is really another way of saying, because I lied long enough and I stuck with my lies long enough, you now have to do it my way because the policy behind the automatic orders can no longer be enforced. Do your honors have any questions?
Oh, I don't. Thank you. And I see no questions. Thank you, Attorney Barndollar. Since we peppered you with questions, Attorney Belcher will give you your full 5 minutes rebuttal. Thank you. Go ahead.
Okay. First of all, in talking about the cases in which there have been remedial orders, the Clement case, for example, there is a distinction in the case law in that they appear to be in terms of orders that certain actions or payments take place pre-judgment. And they seem to arise in the case, for example, payment of a rent or a mortgage, or for payment of support, where the court concludes that it was essentially a liquidated sum that had not been paid, which then could relate to a subsequent order that would be remedial in nature. And that gets over the contempt, the issue of the contempt limitation. This is more problematic because, one, it is a direct property division, and it's a property division that never took into account the fact that Mr. Lampert, if he was not to receive it, would have any adjustment in the amount of the property division he received. And so as a result, it does modify the orders. Yes, one can argue that maybe there's a fair approach, maybe it's a fair thing to do. But the problem is once you undo any part of the property division, and I hate to use the mosaic argument over and over again, but it is the mosaic argument, which is why you don't see those cases in pure property division situations. And I think that's one of the differences here. And in terms of the conduct of my client, of course, the conduct of my client pre-judgment was wrong. There's no question about that. But the issue isn't to argue that the plaintiff's obligated to try to open the case for fraud in order to take advantage of the fact that therefore we're telling him to do it our way. The problem is that I don't think you can have a continuing, for example, in the Clement case, there was a pre-judgment order about making certain payments that was not kept up with. Nothing was here other than the automatic orders, which are orders not to do things. And so at the end of the day, you are left with the actual judgment as it stands, leaving the parties where they are. Counsel's argument, and if you think about it, if this was an Oniglia hearing and she was making the argument that in fact there's evidence of fraud, she would have more than a mere suspicion of evidence of fraud, which would mean that it would be appropriate to proceed on a motion to open. Why would a motion to open be better than what the court chose to do here? It's because then the court can adjust the property division in such a way to do justice to all the parties. And as much as my client may have done something pre-judgment that was entirely wrong, both parties are entitled to justice, however that might fall. And that would be based on the facts as they're developed in basically opening the judgment. When the court goes back and tries to do justice by refashioning this property division, it actually broadened the scope of the actual clause that provided for the Richter. The Richter was considered thank you, there's no little light here, to be the Richter was basically, I think at the time, determined to be a goner and it wasn't going to be there. If in fact, other than getting the Richter, he was to get $200,000, the judgment can simply have said that, which is, okay, if it's not there, $200,000 shifts over to his side, which is now what the court did. And that may have been caused by misstatements on the financial affidavits and for lack of a better term, monkeying around with the $200,000 before the judgment. But that doesn't change the law of the state of Connecticut. And the remedial orders are not a reallocation of property. The remedial orders can be an order that something that was supposed to be paid, but the court can't go back on a remedial order and say, if the financials had been the right way, he would have gotten this, which is sort of what the effect of this judgment is. And so therefore, I think the judgment is the way it is. It may be appropriate to look to open for fraud, but I don't think in terms of the remedial order. And here's my final thing on the remedial order. The facts of this case are intertwined completely with my client's actions pre-judgment. And so the violations of the automatic order essentially form the basis for this remedial action. And that is carrying a pre-judgment contempt into a post-judgment period. And it is not justified under the Papa case, and it's not justified on the other cases that talk about remedial action because it's not. Yeah, this is actually.
You have had plenty of time. I've been generous there. So yes. Thank you both for your strenuous arguments, and we will take this matter under consideration, and the judges will leave. Everyone should leave the hearing room. Thank you.
Thank you so much.
Thank you, Your Honor.
Thank you. Bye-bye.